A Clay County murder defendant who was convicted of assaulting a child earlier this year in Wichita County gets more time behind bars.
Gets out, walks up with the knife. She turns his body over and stabs him somewhere between 7 and 10 times.
A 20-year-old, Karen Fisher, was arrested and accused of running over a man and then stabbing him. Fisher appeared in court for a bond hearing related to the murder charge. The incident took place at a complex where the victim, 64-year-old Stephen Anderson, was walking home from his mailbox when Fisher, a stranger, struck him. Prosecutors described the crime as particularly gruesome. They said Fisher intentionally ran over Anderson with a stolen vehicle, and the entire event was captured on camera.
It was shocking when I saw it.
But the situation didn't stop there.
The brutality is probably the worst I've ever seen in my 10 years at the DA's office.
Prosecutors stated that Fisher allegedly took things even further.
The video shows the defendant running over the complainant, targeting him, and then reversing over him. And then she crashed the vehicle into an apartment complex.
Prosecutors suspected that mental health issues and drugs may have played a role in the attack.
Gets out, walks up with the knife. She turns his body over, straddles him, and then she kisses him, and then slits his throat and stabs him somewhere between 7 and 10 times. And then she gets up and walks away.
In addition to the murder charge, Fisher faced another charge for assaulting a nurse while in the hospital.
Originally, I thought there may be some type of relationship between the complainant and the defendant, but what we know at this point is that there was no relationship. It was complete strangers. So that made it even more shocking and horrific.
Fisher was previously on community supervision for evading arrest in 2023 and had a prior charge of prostitution in 2021, which was later dismissed. Following the arrest, Fisher was charged with murder, assaulting hospital personnel, and evading arrest with a vehicle. Initially, her bond was set at $2 million, but it was later reduced to $900,000. In a jailhouse interview, Fisher expressed no remorse for the attack, describing it as a random act and stating she had zero regrets. As of the latest reports, Fisher remains in custody awaiting further legal proceedings. 5 men appeared before a judge, all but one facing second-degree assault charges.
508 of 24, Yorman.
One by one, they were brought into court, and each man made the same plea.
Not guilty.
These 5 men were indicted in connection with the January 27th attack on an NYPD lieutenant and an officer near Times Square. The first man, Yorman Reverin, arrived in court on his own, but was left in handcuffs with a $150,000 bail, partly due to additional charges of stealing in a separate case. Next was Yohenry Brito, who had been seen in NYPD body cam footage being arrested during the incident. He had been the only one initially held on bail, a $15,000 bail that was paid by a church earlier this week. However, the judge decided it wasn't enough and ordered Brito to remain detained until his next hearing. Kelvin Servita Arocha did not come in voluntarily. He had been taken into custody by ICE agents due to his assault indictment. The judge set his bail at $15,000. Wilson Juarez was not directly accused of attacking the officers, but he was charged with tampering with evidence that could have helped his co-defendants. He had also been picked up by ICE, and the judge set his bail at just $1 to keep him in city custody rather than federal custody. The judge set a much higher bail for Darwin Gomez Isquiel, who faced charges of attacking the officers and acting as a lookout during a theft at Macy's in Queens. His bail was set at $50,000, the highest among the group. The largest police union welcomed the judge's decision, calling it about time.
They should have never been released. These individuals are all behind bars where they belong.
Subsequent investigations led to the indictment of 2 additional suspects, Ulises Bojorquez and a boy, who also pleaded not guilty. By March 1st, 2024, charges against Joan Boada were dismissed after it was determined he was misidentified in the surveillance footage. In May 2024, the Manhattan District Attorney's Office offered plea deals to 6 of the accused. Brito, who had been rearrested for petite larceny while out on on bail was among those offered a plea deal. The proposed plea deals included 1 year in jail for Brito, Bojorquez, and Isquiel for second-degree assault, and 6 months for Arocha and Juarez for obstructing government administration. Reveron was offered 2 years for second-degree assault. In July 2024, Darwin Andres Gomez Isquiel accepted a plea deal, pleading guilty to second-degree assault. He was sentenced to 364 days in jail. In August 2024, Yohenry Brito was indicted on additional charges of petty larceny for allegedly stealing nearly $2,000 worth of merchandise from Sephora stores. As of November 2024, the cases of the remaining suspects, Reveron, Arocha, Juarez, and Brito, were still pending, with no public information available regarding sentencing. A married couple, Brian Washburn and Crystal Washburn, accused of swindling millions of dollars from over 100 pool customers, were sentenced in Indian River County.
I heard because I did their friends' pools and things like that.
Brian Washburn told the judge that he never meant to start projects he couldn't finish. He explained that both he and his wife, who ran Amori Pools together, faced personal and financial difficulties when more than 100 customers complained. Customers had paid tens of thousands of dollars, but while Amori Pools would begin the work, it was often left unfinished. The parts they did complete frequently failed inspections.
My intention was to go to pool, not to take those money and not to whip.
A jury had already found Brian guilty of several charges, including money laundering, using his customers' personal information fraudulently, and operating a scheme to defraud people.
God, if we got our money back, that would be great.
After Brian was escorted out of the courtroom, his wife, Crystal Washburn, was brought in. She was trying to lower her bond to a more affordable amount, as it was set at over $700,000. Her family explained that they were burdened with taking care of Crystal's daughter. Crystal said she hoped to prepare for her trial, earn some money, and spend time with her daughter.
For the past 11 months, my mother and my 22-year-old daughter, Isabella, have taken on the burden of raising my 2-year-old daughter. I need to be able to prepare for both possible outcomes in my case.
The judge said he would issue a written decision regarding Crystal's bond.
30 years in the Department of Corrections.
The judge sentenced Brian to 30 years in prison and ordered him to pay restitution of $3.2 million to the 121 victims. Crystal Washburn, co-owner of Amori Pools, was also sentenced to 30 years in prison for defrauding Florida homeowners. Tanya Bundick, one of the 2 suspects in the Eastern Shore arson cases, faced a judge who denied her bond. Bundick and Charles Smith III were charged with setting nearly all of the 77 fires that terrorized Accomack County over 5 months. What made this court appearance particularly unusual was that, up until then, Bundick had remained silent. Despite repeated attempts to get a comment from her, she had not said a word. However, a remark made about her judgment as a mother caused Bundick to lash out outside the courtroom.
Tanya, Charlie says you set 15 of the fires. What do you want to say about it?
Charles Smith, Bundick's ex-fiancé, also known as Charles Applegate, blamed her for setting 15 of the fires, while claiming he had set 52 himself. Together, they are responsible for 67 of the 77 arson incidents involving unoccupied structures in Accomack County since November.
We've heard from him. What do you want to say?
Come on, get back.
The judge denied Bundick's bond, stating that she posed a risk to the community. Accomack County Commonwealth's attorney, Gary Agar, reminded the judge that Bundick had been setting fires around the county while leaving her 2 sons home alone, sometimes overnight. When asked about this, Bundick became visibly upset. Bundick's attorney, Shannon Dunham, called on a friend of Bundick's, named Robin, to testify. Robin stated that Bundick was a good mother who took care of her sons, expressing shock that she could be involved in the arson cases. However, the judge was unmoved by this testimony and maintained the decision to deny the bond.
What about the fact that she remains a risk to the community, an endangerment to the community because of the severity of what happened over a long period of time?
That's the judge's ruling, and we obviously will appeal that to the circuit court.
Smith admitted to setting 67 fires and was sentenced to 15 years in prison in April 2015. Bundick was convicted on multiple counts of arson and conspiracy. In September 2014, she was sentenced to 10.5 years in prison for 2 arson incidents. Later, in April 2015, she received an additional 7 years for other arson charges, bringing her total sentence to 17.5 years. As of November 2023, Smith was reportedly released from prison and transferred to a halfway house in Roanoke, Virginia. Bundick's release date is set for September 2025. Robert Zuccari, his girlfriend Janyan Ano, and Nicholas Thyssen knocked on the door of a woman's apartment in Hampton, claiming to be bail recovery agents. They then allegedly forced their way into her apartment, handcuffed her, and pointed a black semi-automatic pistol at her head.
One of the gentlemen handcuffed her, the other one had a gun to her head, asked her a bunch of questions about some people that may have been in her apartment previous that day.
The entire incident lasted about 15 minutes, according to police. The suspect told the victim that they were looking for some people wanted by authorities. However, the case ended with the suspects being arrested and taken into custody by the police.
He had some credentials about being some sort of federal bail agent, but I don't think we've been able to determine if that's in fact true or not.
Police stated that bail agents are supposed to follow certain protocols, which these three suspects failed to do.
They are supposed to check in, with the local police departments, and they're supposed to be bonded by the state of New Hampshire, to even do these things.
According to police, the trio then interrogated the woman for about 15 minutes before removing the handcuffs and leaving the apartment. Zuccari, Thyssen, and Ano were charged with the felony of criminal restraint. A search was launched in Volusia County to find Antonio Gearing. Investigators said that Gearing walked away from the courthouse while the jury was deliberating his armed robbery case. Since he was out on bond, he wasn't restrained in court and simply left the courtroom.
I think he saw the writing on the wall.
Antonio Gearing, 29, became a wanted man after ditching his trial. He left the courthouse, walked through the parking lot with others, and got into a white SUV.
He's free to walk around until the verdict is rendered, and if he's found guilty, typically they would revoke the bond and take him into custody.
Gearing had been released on a $75,000 bond and was allowed to move freely as long as he attended court dates and followed the conditions of his release.
So it is a bit more unique to have it happen kind of right at the very end, but I suspect again it's because the defendant knew that he was about to be found guilty of some very serious charges.
He faced charges of armed robbery and aggravated assault with a deadly weapon after robbing a Dollar General store. During the robbery, he struck a clerk with a gun.
You have to assume he's armed, and you know from his history that he's dangerous.
Federal, state, and local agencies were all involved in searching for Gearing and trying to identify the driver who helped him escape.
If there is a way, not infringing upon folks, their constitutional rights while they're awaiting a verdict during a trial, or while they're awaiting trial for that matter, but simply trying to learn from this episode and see if there is something we can do.
The state attorney announced plans to meet with the Volusia County Sheriff to discuss steps that could prevent such an incident from happening again. In August 2019, the search came to an end as Gearing was apprehended and arrested. In October 2024, Gearing filed a federal habeas corpus petition challenging his conviction and seeking relief from his sentence. The case is currently pending in the U.S. District Court for the Middle District of Florida. Sidney Holmes, a man overwhelmed with emotion, was set free after spending 34 years in prison. He had been incarcerated since 1989, and as soon as he stepped out of the Broward County Jail, his family greeted him with tears of joy. Holmes shared that the first thing he wanted to do was go out to eat. He was deeply moved by the moment, reflecting on the long 34 years he and his family had endured during his wrongful imprisonment. Despite the emotional release, his immediate thought was simply to enjoy a meal. After 34 years, Sidney Holmes was finally a free man. His family, equally emotional, watched as he took his first steps out of the jail.
I can't put into it. It's overwhelming.
I was over-elated. I was excited. And I just kept praising God and thanking Innocent Project and everybody who made this possible.
Back in 1988, Holmes had been convicted of being the driver in a robbery. However, during the court proceedings, the state attorney explained that Holmes had no connection to the actual robbery. There was no physical evidence or fingerprints tying him to the crime. The state noted that one witness's mistaken identification led to Holmes's wrongful conviction and a 400-year sentence.
Here's a man who was sentenced to prison for 400 years, which is effectively a life sentence. And today we were able to reverse that. He's getting out of prison today, and no longer is the wrong man confined to a Florida State prison.
It has been a long time, long awaited day.
Despite the years spent behind bars, Holmes's family never lost hope. The Innocence Project celebrated his release, though they also pointed out that there are up to 5,000 other inmates in Florida prisons who may also have been wrongly convicted.
We are reviewing hundreds of cases in our office to find the next Sidney Holmes, and have cases in Broward County that are on deck, and so we're going to continue plugging away.
When asked what he wanted people to know, Holmes shared a message of hope. Never give up hope. After all he had been through, Holmes expressed that he now wanted to spend the rest of his life doing something very special. Keandra Young, one of 2 customers, was charged with a hate crime in connection with an attack on Young Kim, the owner of a beauty supply store. The assault took place on St. Patrick's Day. The owner's son, Sam John Lee, shared that his family received a lot of support from customers and the community since the attack on his mother.
I just want the justice. Get a punishment what they did, like not over, not less, just like exact amount what they did. That's just what I believe in. That's what I want.
The incident was captured on surveillance video, which showed Young Kim being punched by one of the customers, in addition to racial insults.
Like, you little Asian girl. That's what she remembered.
Dakiesha Williams and Keandra Young, both charged in the attack, claimed Kim was profiling them, saying she had followed them and their friends when they entered the store.
They showed you certain clips of the video to make it seem like it was these angry black women just randomly attacking people, and that's not the case.
A month before the assault, Young was also accused of running over Kim's son and father in the parking lot, adding to the severity of the situation.
If somebody's jumping in front of your car with a weapon and you're trying to bag up, I have somebody in the front of me and the back of me. I have no choice but to go forward.
Lee, who denied all the women's claims, mentioned that his mother was recovering and that the family just wanted to move past this painful ordeal.
I don't really feel upset or sad, just like nothing, because we're in the we're going back to the normal life.
If Keandra Young is convicted on the assault charge, she could face 180 days up to a year in county jail, thanks to the hate crime enhancement. Navon Johnson, 24, pleaded guilty to her involvement in a prostitution case in Macon that involved exploiting a girl.
I'm sorry. I'm sorry for the mistakes that have been made. I'm sorry for my lack of judgment. But I just want you to know that I am not a menace to society. I am no threat to making or to people. I intend to be something great one day. I intend to be a good mother to my daughter and a good daughter to my mother. If I can take that one, I can. I'm just saying that you thought maybe I've already been given a second chance. But I'm asking you today, Judge, that I will not let you down if you give me a second opportunity to prove to you in the court that I'm not a hazardous. I'm not a threat to anyone.
You get a degree from taking whatever it is. Really might be considered a copy. So that every single thing about this yeah, you're gonna have to gain this they'll travel along and get gained in the year or two. They have a learn.
Judge Howard Sims sentenced Johnson to 10 years of probation after she had been in jail since her arrest in June 2014. Additionally, she was ordered to spend 180 days in a probation detention center and complete 80 hours of community service. Brittany Rouleau, a defendant in a Clay County murder case, was convicted in Wichita County for assaulting a boy. In May 2024, she was sentenced to 60 years in prison for aggravated sexual assault. Subsequently, in August 2024, she pleaded guilty to prohibited sexual contact with an ancestor, or descendant. Judge Charles Bernard from the 89th District Court sentenced her to an additional 15 years in prison. Rouleau has since filed an appeal, arguing that the trial court did not allow key evidence that could have cleared her name, which she claims denied her the right to an effective defense. While out on bond for these charges, Rouleau was arrested in March 2023 for the murder of 57-year-old Kenneth Dwayne Douglas in Petrolia, Texas. She is currently awaiting trial for this murder charge in Clay County. Shaylin Marie Robinson, a former detention officer, was set to serve her own jail sentence after pleading guilty to charges of having inappropriate sexual contact with women in custody. On December 15, 2023, the 23-year-old woman pleaded guilty to all 4 counts of violating the civil rights of a person in custody. Robinson had been first arrested in February 2023 after accusations surfaced that she had an intimate relationship with an inmate while working at the jail. After being terminated from her position, she was rearrested and faced 4 new charges after an internal investigation revealed that she had engaged in sexual contact with 2 different female inmates on 4 separate occasions. According to sheriff's officials, Robinson had only been employed at the jail since December 2022. 78th District Judge Meredith Kennedy sentenced Robinson to 5 years in the Texas Department of Corrections for each charge, with the sentences to run concurrently. She was also credited with 275 days for time already served in jail. In December 2016, a tragic incident unfolded in Lorain, Ohio, when an attempted robbery led to the death of 23-year-old David Barrero and ultimately resulted in the conviction of Abilene Cannon. On the night of December 10, 2016, Cannon and an accomplice forcibly entered Barrero's apartment on Shore Drive with the intention of robbing him. Barrero, attempting to defend himself, was armed. A confrontation broke out, leading to a shootout. Barrero tragically lost his life, sustaining gunshot wounds, while Cannon fled the scene after being injured. Cannon was apprehended shortly after and faced numerous charges, including aggravated murder, robbery, kidnapping, and tampering with evidence. Prosecutors presented evidence that painted a clear picture of premeditation and intent behind the robbery, which tragically escalated into violence. The case also drew attention to Cannon's extensive criminal record, which included 21 felony convictions for offenses such as drug trafficking, robbery, and assault. In 2018, a jury convicted Cannon on 13 of the 14 charges against him, acquitting him of 1 count of murder. During the sentencing in January 2025, both the prosecution and Barrero's family urged the court to impose the harshest penalty of life without parole, emphasizing Cannon's history of criminal behavior and the devastating impact of the crime on the victim's loved ones.
Despite the fact that this is an awful case with terrible facts. But a minimum sentence would be inappropriate, disrespectful to the family, and demean the seriousness of this conduct. Mr. Cannon, I find your criminal record to be incorrigible. You spent almost your entire adult life as a criminal. You've wreaked havoc on communities, and you've wreaked havoc on people's lives. You have, by my count, approximately 21 adult felonies. Have been to prison twice, neither of which made an impact or affected you in a positive manner to change your lifestyle. And as you sit here today, you've graduated from trafficking in drugs, robbery, weapons charges, and felonious assault to murder. Based upon all the relevant sentencing factors in this terribly senseless crime, I find you to be essentially today irredeemable and unrehabilitatable. But I do believe that to take all hope from you would be inappropriate given the totality of the factors. Accordingly, this court has considered the entire record, the oral statements presented, the overriding purposes and principles of felony sentencing pursuant to 2929-11, considered the seriousness and recidivism factors relevant to the offense and the offender pursuant to 2929-12, and considered the need for deterrence, incapacitation, rehabilitation, and restitution. Excuse me. It's the judgment of this court in the sentence of law that a prison sentence is consistent with the purposes and principles of felony sentencing pursuant to 2929-11. The defendant is not amenable to a community control sanction, nor is one available in this case due to the seriousness of the defendant's conduct and its impact on the victims. A prison sentence is reasonably necessary to deter the offender in order to protect the public from future crime, and a prison sentence will not place an unnecessary burden on government resources. Accordingly, it is ordered the defendant shall serve terms of incarceration at the state penitentiary or Lorraine Correctional Institution as follows. Count 1, aggravated murder, a life term with no possibility of parole for 30 years. The specification attached to that life term, 4.5 years for an aggregate sentence of 34.5 years. Count 11, felonious assault, 4 years incarceration to run consecutive for an aggregate term of 38.5 years. Count 12, temporary tampering with evidence, 18 months or a year and a half to run consecutive for a total aggregate sentence in this case of life in prison with the possibility of parole after 40 years. Count 14, having weapons under disability, 18 months will run concurrent to all other charges. In finding and ordering consecutive sentences, this court finds that these crimes, that multiple criminal offenses were committed in a similar course of conduct, multiple victims were affected. The harm was so great or unusual that a single term does not adequately reflect the seriousness of the conduct, and the defendant's criminal history shows that consecutive terms are needed to protect the public. The defendant is granted credit for all time served in custody on this case, as well as with any future transportation days, and he is ordered not to ingest or be ingested with any drug abuse as he'll be subjected to drug testing in prison. Because you are being sentenced on some charges that do not carry or that are definite sentences, I'm going to advise you of post-release control. Post-release control in your case is mandatory for a period of 3 years. What that means is if you're ever released on anything other than the aggravated murder charge of firearm specification, you will be placed on post-release control for a period of 3 years, mandatory. If you are placed on post-release control and you violate the terms of post-release control, the adult parole authorities can return you to prison for up to 9 months for each violation, up to a maximum of 50% of the stated prison term for all violations. If you're convicted of a new felony while in post-release control, in addition to being punished for the new offense, the court can terminate the term of post-release control and impose a prison term for the post-release control violation.
Cannon's defense attorney argued for leniency, suggesting a minimum sentence that would allow for parole eligibility after 24 years. However, Judge Chris Cook opted for a middle ground, sentencing Cannon to at least 40 years in prison with the possibility of parole in 2057 when he would be 78 years old. The judge explained his decision, stating that life without parole would strip Cannon of any hope for redemption, while a minimum sentence would fail to honor the gravity of the crime. Addressing Cannon directly, Judge Cook noted his progression from lesser offenses to murder, underscoring the seriousness of his actions. Following his conviction, Cannon appealed the verdict, challenging the sufficiency of the evidence and alleging errors in the trial process. However, in 2020, the 9th District Court of Appeals upheld the convictions, affirming that the evidence supported the jury's decision and that no reversible errors had occurred during the proceedings. As of 2025, Cannon remains incarcerated at the Southern Ohio Correctional Facility, serving his sentence with no significant changes to his legal status. His parole eligibility is set for December 2056, offering a distant possibility of release. In February 2024, a tragic incident unfolded in Elyria, Ohio, leading to the death of 79-year-old Malcolm Waters and the arrest of his 20-year-old grandson, Joseph Ward. What began as a domestic dispute escalated into a devastating event that left a family and community in shock.
This incident took place on February 21st, 2024 at approximately 11:13 p.m. Officers were detailed to 471 Bonnier Avenue for a protection order violation complaint. Upon arrival, officers spoke with the complainant, Laura Napier. She stated that Joseph Ward was outside her home at approximately 11:10 and broke one of her side windows of her home. She is the protected party in a post-conviction no contact order, and she stated that she was inside and heard 2 loud bangs outside her home. She stated that she then heard glass break. She checked cameras on the exterior of her home and saw Mr. Ward standing between her house and a fence that he had banged, and that he had banged on her daughter's window. He also had broken one of the windows on the north side of the home before running away. She stated she could hear his voice on the camera, so she knew it was him by his voice alone. The camera footage was observed by police, and they saw the same as described, and the defendant was not present at the time as he had left that scene. Shortly later, approximately 11:22, a first call for service came in on Wednesday, February 21st, 2024. At 11:22, officers responded, and Detective Lesh responded at 12:13 a.m. He was called to assist in an active investigation of a homicide which had occurred at 533 Ogden Avenue in Elyria. Upon arrival, he observed Malcolm Waters, resident of 533 Ogden Avenue, laying deceased in a pool of blood in the living room.
Joseph Ward had been living with his grandparents, Malcolm and Pamela Waters, at their home on Ogden Avenue. Earlier that evening, police were called to investigate a protection order violation involving Ward at a separate residence. Laura Napier, the protected party in the no-contact order, reported that Ward had been outside her home, breaking windows and causing a disturbance. Surveillance footage confirmed Ward's presence, but he fled before officers arrived. Shortly afterward, another call came in from the Waters home regarding a domestic disturbance.
Detective Lesh and Sergeant Wise interviewed the deceased wife, Pamela Waters. She advised that there had been a noise disturbance at her residence at 533 Ogden Avenue that evening. She stated that it was caused by her granddaughter and some friends. She confronted the disturbance and it eventually dissipated. She states that then her grandson, Joseph Ward, who also resides with her at that address, began shouting at her and told the in-home nurse to quote unquote get the out, and was pointing a black hand at her and then also at Pamela's head. He then struck her multiple times with the hand, including in the left side of her head. She stated that she was in the fetal position to protect herself, that when she looked up, she observed Joseph holding her husband, Malcolm Waters, at gunpoint, that she exited the living room out of French doors, which exit directly outside, and ran to a neighbor's home and had them call police. She states that once police were on scene, she advised them that the entire incident should have been captured on Arlo camera systems inside the home. Detectives reviewed the footage from the camera and observed Joseph holding Malcolm at gunpoint, threatening to kill him if he was too loud. Malcolm could be seen covered in blood at this point, begging Joseph to let him sit down. Eventually, he did allow Joseph to sit down, and after attempting to shoot him several times with a firearm, he picked up a shovel and struck Malcolm in the head multiple times until Malcolm appears to lose consciousness. Malcolm sustained fatal injuries. Joseph is then seen dumping Malcolm from the chair he was sitting in onto the concrete and proceeds to drag his body back into the living room and thereafter flees through a bedroom window.
According to Pamela Waters, there had been earlier disruptions at the residence involving their granddaughter and her friends. After addressing the issue, Ward became agitated and began arguing with Pamela. He allegedly pointed a firearm at both Pamela and an in-home nurse, yelling at the nurse to leave. Pamela stated that Ward struck her several times, forcing her to seek refuge at a neighbor's house, where she called the police. Meanwhile, inside the house, security cameras captured a tense exchange between Ward and Malcolm. Ward was seen holding his grandfather at gunpoint and threatening him. Malcolm, visibly distressed, pleaded for leniency. After a heated confrontation, Ward inflicted fatal injuries on his grandfather and then fled the scene through a bedroom window.
Later, approximately 0400 hours, officers were detailed to 605 Abbey Road North, apartment B3, in reference to Joseph Ward showing up covered in blood and being asleep on the couch of this residence. The resident of that apartment states that she left the front door unlocked for police and that she and a friend were hiding in the bathroom while awaiting police arrival. At that point, police encountered Joseph and arrested him without incident. He was Mirandized, asked if he understood his Miranda rights, and he answered in the affirmative. He was asked if he had any knowledge or involvement in the murder of his grandfather. He informed police that he had no knowledge of it and was not involved. They stated that the entire incident had been captured on camera and that he was seen committing this crime.
Hours later, at approximately 4 a.m. on February 22nd, police were called to an apartment on AB Road, where Ward was found asleep on a couch, covered in blood. The apartment's resident had unlocked the door for authorities and hid in the bathroom with a friend until police arrived. Ward was arrested without incident. During questioning, he denied any involvement in the incident despite being informed that it had been captured on video. He requested an attorney, ending the interview.
He was seen committing this crime, and he continued to refuse acknowledgement of his brutal crime. At that point, he asked for an attorney and the interview ended. The firearm that was utilized was located at the homicide scene and is currently in evidence. It should be noted that Mr. Ward is currently under indictment for weapons under disability in a case at Lorain County Municipal Court. His history includes juvenile adjudications of robbery and theft and resisting arrest from 19, an additional robbery and theft from 19, a domestic violence, aggravated menacing, resisting arrest, assault ×2, harassment of an inmate, disorderly conduct, disrupting public service, all from 20, a VPO, violation of protection order, from November of 23, and a criminal damaging charge from the same date in this court, in Judge White's court.
The firearm used in the incident was recovered at the Waters residence and taken into evidence. Ward was charged with 21 counts, including aggravated murder, kidnapping, and felonious assault. His criminal history included prior charges for robbery, theft, domestic violence, and violating a protection order. The court set bonds totaling $4.5 million, including $2 million for the felony assault involving Pamela Waters and $2 million for the murder of Malcolm Waters.
Cash or surety bond on the felony 2 felonious assault involving Pamela Waters. There'll be a $2 million cash or surety bond. On the felony 2 felonious assault involving Mr. Waters, I'll give him a personal bond on that one since he's getting a bond on the murder. On the felony 3 weapons while under disability, it'd be a $500,000 cash or surety bond. So in cases ending in 444, there's $4.5 million bonds. On the domestic violence misdemeanor 1, there'll be a $5,000 cash or surety bond. In the violating a protection order, there'll be a $5,000 cash or surety bond. That was $500,000 Jane on the disability.
Ward underwent a competency evaluation to determine if he could stand trial. In October 2024, Lorain County Common Pleas Court found him competent, ruling that he understood the charges and could assist in his defense. Plea negotiations have been ongoing, with his bond set at over $6.5 million now. As of January 2025, Joseph Ward remains in custody at the Lorain County Jail. The legal proceedings are ongoing. In May 2014, a shocking case unfolded in Waukesha, Wisconsin, involving 3 girls and a chilling belief in a fictional internet character, Slender Man. Morgan Geyser and Anissa Wire devised a plan to harm their classmate and friend, Peyton Leutner, whom they referred to as PL, in court. The girls believed that carrying out this act would prove Slender Man's existence and protect their families from harm. They also thought it would allow them to become proxies for the character, granting them entry into his supposed mansion in the woods.
There was a plan that was put into action that involved myself, the co-defendant, and another one of our classmates, along with the want to please a fictional character. And the plan was to hurt the other classmate or kill the other classmate. And that plan was put into action but failed on the day that I got arrested, May 31st, 2014.
So who was the other actor?
The other defendant?
Other defendant, correct.
That would be Morgan Geyser.
And who was the classmate you wanted to kill?
I've put her through enough already, Judge. I don't feel like saying her name.
You can just say her first name, that's fine.
Okay, her name's Peyton.
All right.
The plan was initially devised weeks in advance, with the intention of carrying it out on May 30th, 2014. However, Morgan and Anissa decided to delay until the next day. On May 31st, the three girls went to a local park under the pretense of spending time together. They played on the playground before leading Peyton into a nearby wooded area. Anissa later recounted that she began to realize the seriousness of the plan when Morgan revealed a knife hidden in her waistband. Despite this, both girls felt compelled to follow through with their misguided belief in Slender Man.
We woke up. A number of different things happened that really have no significant meaning here. Morgan and I decided that we would make an attempt to fulfill the plan at the park. This was around 10 o'clock, I believe. We went to the park. I didn't realize that it was actually going to happen until Morgan lifted up her waistband and showed me the handle of the knife. We were just playing on the playground for a while. After a while, we went into the bathroom. Morgan told me to Peyton. I told her that I couldn't do it. She tried getting me to do it again. I told her that I couldn't do it. A while later, we went into the woods, and that's when Morgan asked me whether or not she should do it, and I just wanted it to be over with. So I said, just go berserk, do what you have to do, and Peyton was then hurt. And
So how was she hurt?
Morgan jumped on top of her and stabbed her repeatedly.
And what happened at a certain point, the two of you left?
Yes. Afterwards, I told Peyton to lay down and that she would lose blood slower, pardon my slip up. Then Morgan and I left and ran.
In the woods, Morgan asked Anissa if she should proceed. Anissa, feeling overwhelmed and unsure of what to do, told Morgan to go berserk and do what you have to do. Encouraged by Anissa's words, Morgan tackled Peyton and carried out the plan. Afterward, Anissa reassured Peyton, telling her to lie down and remain quiet, falsely claiming this would help her recover. The two girls then fled the scene, believing they had completed their task. They began walking toward Nicollet National Forest, where they thought Slender Man's mansion was located. Despite her injuries, Peyton showed incredible determination. She managed to crawl to a nearby path where a passing cyclist found her and called for help. Emergency responders quickly arrived, and Peyton was taken to the hospital. Her survival was described as miraculous, with her injuries narrowly missing critical areas. Peyton's resilience became an inspiration to many. Later that day, Morgan and Anissa were apprehended near a highway. During questioning, both girls confessed to their roles in the incident.
Yes, I'd like you to tell me, in your own words, what you did on May 31, 2014. What happened between you and Peyton and Anissa Wire, as well as PL.
Anissa and I took PL into the forest and said that we were gonna play hide and seek. And Anissa said that she couldn't do it, and that I had to.
You can take a minute to catch your breath. That's fine. But what I'm going to ask you, what I need you to tell me is what you did. So relax a minute, take a couple breaths. That's fine. We have all afternoon.
So I tackled her and I stabbed her.
Well, tell me about the tackling. How did you do that?
I came up from behind her and I jumped on her.
And then what happened?
And then I stabbed her.
So did PL fall to the ground?
Yes.
And after she's on the ground, where were you?
On top of her.
And was PL on her back?
Yes.
So then when she's on her back, how did you do that?
I stabbed her with the knife that I had taken from my house earlier that morning.
Now, when you say you stabbed her, were you somewhat straddling her?
I think so.
Morgan explained that she believed harming Peyton was necessary to prove Slender Man's existence and to protect her family. She admitted to hearing voices and experiencing delusions, which fueled her belief in the fictional character. Anissa, while not diagnosed with a mental illness, admitted she had been influenced by Morgan's conviction and shared her fear of Slender Man.
Well, why did you develop the plan to kill?
We developed... Okay. I thought that it was just about proving that this fictional character existed. But I have no idea what Morgan's motivations were. I thought it was just about proving that something most people thought wasn't real was.
So this is, and who are you talking about?
The character?
Right.
Slender Man.
All right. Why did, what motivated you to conclude that you had to kill someone in order to follow through with whatever program you had with Slender Man?
It wasn't my idea. Morgan came to me one day telling me that we should prove that Slender Man existed, and I asked her how, and she said we had to kill somebody, and I said okay, because I thought it was just a joke, honestly. I didn't think it was actually gonna happen, but it obviously did.
Did you feel any compulsion to go through with the plan?
I didn't want to hurt Peyton. I wanted to prove that Slender Man existed, but I thought that there were other ways. Morgan told me that there were other ways of becoming a proxy and proving that Slender Man existed, but I asked her what those were, and she said that she didn't want to talk about it because killing someone was the easiest way.
Was there any concern on your part, talking about you, if what would happen if you didn't go through with the plan?
I believed that if I didn't go through with the plan, Slender Man would come and attack and kill myself, my friends, and my family, those I cared about most. And I was afraid that if I did not go with Morgan and help her, that she would find a way to elude authorities or anyone else who was looking for her and come back and finish what she had started, I guess, just me, which is why I went with her.
The legal proceedings revealed the extent of Morgan's untreated schizophrenia, which had caused her delusions. Both girls were charged with attempted first-degree intentional homicide. Their cases were tried in adult court due to the severity of the crime. In 2017, both girls entered plea deals. Morgan pleaded guilty, but was found not guilty by reason of mental disease or defect and was sentenced to 40 years in a psychiatric institution.
When I put it all together, the 40-year commitment appears reasonable and fair, taking into account the unique circumstances of this case. So I'm going to order that the commitment be for 40 years. It's a long time, and when I think and reflect on it, 40 years to a 15-year-old, what a long time that is. Yet there's more to it than just Ms. Geiser. Our focus, to some extent, is on what her status is today. But this is an issue of community protection. This is an issue to be sure there's no recidivism. This is an issue to ensure that Ms. Geiser doesn't have a revolving door situation where she ends up being in the community and then things fall apart and she comes back. Everyone who's in the legal system that's dealt with mental health issues from an NGI standpoint or from a civil commitment process know that individuals with mental health issues, as well as they're medicated, as well as they're taken care of, frequently come back because they decompensate, something happens. The court has to be sure that when that happens, there's control, there's supervision. Thus, the length of the commitment, I believe, is appropriate at 40 years, and that'll be the order of the court, so ordered.
Anissa also pleaded guilty and was similarly found not guilty by reason of mental disease or defect. She received a 25-year sentence, which included mandatory treatment and supervision.
She has to do it keeping in mind, as I think she knows, of what happened and the community's perception of what happened. So I'm satisfied the 25-year commitment is appropriate.
During their sentencing, both expressed deep remorse for their actions. Anissa admitted her responsibility.
I just want everyone involved in this to know that I do hold myself accountable for this and that I will do whatever I have to do to make sure that I don't get any sort of delusion or whatever again. And I want everybody involved to know that I deeply regret everything that happened that day and that I know that nothing I say is going to make this right, Your Honor, and nothing I say is going to fix what I broke. I'm just hoping that by holding myself somewhat accountable and making myself responsible for what I took part in that day, that I can be responsible and make sure this doesn't happen again. I'm never going to let this happen again. I'll do whatever I have to do to make sure that this doesn't happen. And I know you've heard that before and you're probably going to hear it again, but it's the truth.
Morgan, too, expressed regret, apologized, and said that she didn't want to hurt anyone.
I just want to let Bella and her family know I'm sorry. I never meant this to happen. And I hope that she's doing well.
Their statements highlighted the delusion and fear that had driven their actions. In 2021, Anissa was granted conditional release after serving 7 years in a mental health facility. Her release included strict supervision, therapy, and GPS monitoring. Morgan, who petitioned for release multiple times, was approved in 2024 after experts testified to her progress in managing her schizophrenia. Like Anissa, her release is conditional and includes ongoing treatment and supervision. Peyton, the victim, demonstrated extraordinary strength throughout her recovery. In a rare interview, she expressed forgiveness toward Morgan and Anissa, but made it clear she preferred no further contact with them. Her focus has remained on rebuilding her life and moving forward, becoming a symbol of resilience. On May 14, 2024, a quiet morning in Marion County, Florida, turned into a day of sorrow when a bus carrying farm workers veered off the road. The accident occurred on West State Road, 40 near Dylann, involving a 2010 International bus and a 2001 Ford Ranger pickup truck driven by 41-year-old Brian Howard. The bus, carrying 53 farm workers to Cannon Farms, overturned, resulting in the loss of 8 lives and sending more than 30 30 passengers to local hospitals. Authorities soon identified Brian Howard as the driver of the pickup truck, which had allegedly sideswiped the bus. After the accident, law enforcement noted Howard appeared disoriented. During questioning, he admitted to using marijuana oil and taking prescription medication the night before. Though his breathalyzer test showed no alcohol, he failed field sobriety tests, raising concerns about possible impairment.
All right, Mr. Howard, you're before the court. You're charged with 8 counts of DUI manslaughter.
The following day, on May 15th, 2024, Howard appeared in court to face 8 charges of DUI manslaughter.
The defendant has convictions for leaving the scene of an accident with property damage in 2019, 2 convictions for driving while license suspended, canceled, or revoked, second offense in 2018, grand theft in 2013, driving while license suspended, conviction in 2013, possession of cannabis, conviction in 2009, leaving the scene of an accident in 2006. And Your Honor, the state would argue and ask for no bond on these charges, given his history of driving with a suspended license. Additionally, there were 33 passengers taken to the hospital, so there may be charges of further injuries for those passengers. And the defendant admitted to law enforcement that he was in the crash 3 days prior to this. It's clear that he drives with a suspended license, and so to guarantee that he's not operating a motor vehicle, we would ask for good bond.
The prosecution painted a troubling picture, emphasizing Howard's history of traffic-related offenses. These included driving with a suspended license, leaving the scene of prior incidents, and other violations spanning over a decade. They argued that Howard posed a public safety risk, citing his admission of involvement in a minor collision just 3 days before the bus crash.
You want me to consider appointing an attorney for you, or you plan on hiring private counsel?
A public defender.
Are you employed, sir?
Self-employed.
And where are you self-employed? What business are you running?
BHM maintenance. It's called
Say that again?
It's called BHM maintenance. I paint and drywall.
And how long have you been self-employed, sir?
For about 7-8 months.
And how much do you make on average per month?
$1,200.
Do you have any dependents that you're supporting out of that?
No. No, ma'am.
Do you have any other assets that you own?
No, ma'am, not at the time.
And do you have any money in the bank?
Yes, ma'am.
And how much do you have?
$700.
All right, based on the information that you have provided to me, this court does find that you qualify for the services of the Public Defender's Office. I will appoint the law officer Michael A. Graves to represent you, sir.
Okay, thank you.
During the hearing, Howard revealed that he ran a small business, BHM Maintenance, earning about $1,200 a month. With only $700 in savings and no other significant assets, the court appointed a public defender to represent him.
All right, Mr. Howard, given the nature of the charges and given the possibility of further pending charges, right now, this court is going to hold you on a no bond on all 8 counts, sir. And given your history of driving offenses and that you prior leaving the scenes of an accident. And I did read, as the state pointed out, that you were in an automobile accident at least 3 days prior to this accident. You are not allowed to operate a motor vehicle while this case is pending, sir. And you are not allowed to consume or possess any alcoholic beverages, any controlled substances, or any take any kind of prescription drugs without a prescription. And there's, of course, a general rule, no illegal substances. I believe it was, allegation was some type of marijuana oil too. Sir, do you understand these conditions that I'm putting in place?
Yes, ma'am.
Despite his defense team's request for a standard bond, the judge ruled to hold Howard without bond, citing the gravity of the charges and the potential for additional allegations related to passenger injuries. The judge outlined conditions for Howard. He was forbidden from driving any vehicle or using non-prescribed substances while awaiting trial. The decision reflected a commitment to public safety and a recognition of the severe consequences of impaired driving. In June 2024, Howard entered a plea of not guilty. His defense team began preparing for trial, challenging the evidence of impairment and its connection to the accident. Meanwhile, the prosecution built its case, relying on forensic analysis, eyewitness testimony, and the events leading up to the incident. Initially scheduled for October 2024, the trial was postponed to allow more time for preparation. As of January 2025, the trial is set to begin on May 15th, 2025, 1 year after the accident. The upcoming proceedings are expected to focus on the evidence surrounding Howard's actions and their impact on the victims and their families. If convicted, Howard faces the possibility of life in prison. Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.